Okay, good evening, everyone. My name is Attorney Mike Crotty. I'm the solicitor for Schuylkill Township. The first thing on our agenda for tonight is a conditional use hearing for 1485 Valley Forge Road. A conditional use is a zoning hearing where the board up here sits as the judge of the application. The applicant gets to come in and present their evidence and testimony as to why they show that they can meet the ordinance criteria. And then anyone who wants to be a party, and I'll go through that in a second, and wants to present their own evidence and witnesses has an opportunity to do that. They also have a chance to cross-examine the applicant's witnesses and evidence. And then ultimately, the board up here as the judge will make a final written decision on the application. As you can see, this is part of a larger agenda for tonight. I expect procedurally that we'll go probably like an hour and a half or so, depending on natural break point. And then if we're not concluded by then, we'll continue to likely our March meeting, but we'll discuss all that at the end of the meeting. Before I get into any of the mechanicals in terms of the application that's before us and the party status requests, I do have a number of board exhibits that I'm going to enter into record. The first is Exhibit B as in Board 1. That's the application that was filed under Section 370-55 for demolition of a historic Class 1 or Class 2 historic resource in the township. That does include, the version I have does include the attachments that were submitted with the application. Exhibit B2 is the notice that was in the newspaper for tonight's hearing. It was advertised twice. Exhibit B3 is a letter dated December 23rd from counsel for the applicant just to confirm an extension of the first date on which the hearing has to be held. Exhibit B4 are the neighbor notice letters that went out to everybody within a certain number of feet of the property. Exhibit B5 is the proof of publication that the notice was advertised in the newspaper. And Exhibit B6 will have as the affidavit of posting that the property was posted by the Township Zoning Officer. Note that this is a formal / semi-formal proceeding. We do have a court reporter up front because she's creating a record. So if you want to speak, you have to come to the microphone. Make sure to slow down, which is hard for all of us, so that she can capture what you're saying. Only one person can speak at a time because as great as she is, she can't type out everything that everyone's saying all at once, and wait to be called on, obviously. The board up here is the judge. If we end up not concluding tonight, no one can talk to them about the application. They're consider them in a bubble. The only thing that they can consider is what's presented before us at the hearing tonight and any future hearings. As I noted before, if you'd like party status, there is a form up front that I'd ask you to come fill out. Party status gives you the chance to ask questions of the applicant's witnesses, to present your own testimony and evidence related to this application, and then if you disagree with whatever decision the board makes, you can appeal that to the Chester County Court of Common Pleas. With that being said, is there anyone here who would like party status? And just come up to the microphone, please, one at a time. If you haven't had a chance to fill out the party status request form, please do so before you come up, and we can take you one at a time.
Yes, I'm Keith Wickstrom, 27 Flintlock Lane. Yes, Wickstrom.
And Keith, how far away are you from the property?
We're less than 300 feet. We abut it. I'm sorry, we abut it.
And, I'm sorry, Keith, you can bring it right up to me.
Hi, my name is Mark. Oops, sorry.
Mark, before you do that, we have Ms. Zarro here for the applicant. She has a chance to ask any, Keith, please don't go too far. She has a chance to ask any questions of any witnesses, or not any witnesses, anyone seeking party status. There's also Attorney Michael Gill. He represents the Historical Commission and the interests of the township. There's no interface between he and the board. He's just presenting the position of the township and their reviews. So Ms. Zara, do you have any questions of Mr. Wickstrom? I do not. Okay. Any objection to him getting party status? No objection. Okay. Next.
Mark, M-A-R-K, Harvell, H-A-R-V as in Victor, I-L-L. I live at 63 Flintlock Lane. I got a letter for the 300-foot line, and my property abuts the property behind as well.
No objection.
Thank you.
Thanks, Mark. You're right up here. Hey, that'd be good, yeah. Thank you, sir.
Hello. Megan Tribuno, Megan Tribuno, at 33 Flintlock Lane. I received the letter that my property is within the 300 feet of the historical building, and my property abuts as well.
Julie Pace, Julie, P as in Peter, ACE, 23 Flintlock Lane. I received the letter that my property is within the 300 feet of the building, and mine also abuts to the property.
Thanks, Julie. If you can just hand up your form to Paul. Thank you.
Hi, Dana Jacob, Dana Jacob, 54 Flintlock Lane. I also received the letter that my home is within 300 feet of the property. I'm on the other side of the street on Flintlock facing the property.
Amir Kavalchuk, Mirka Walczak. I'm at 51 Flintlock Lane, and my property is right in the, what's that word? Abate? Yeah, that, yeah, to what we're talking about.
I am Ellen Barry. I live at 45 Flintlock Lane, and my property abuts the property as well.
Jameson Glennon, Glennon. I own 20 Emmett 30 McKinney Lane, and my property abuts the property.
Thank you, sir.
My name is Mary Donovan, Donovan. I live at 26 Flintlock Lane. I got a letter in the mail saying I'm within 300 feet. So I'm within 300 feet.
Abigail Freed, Freed. I live at 15 Flintlock Lane. I received a letter that my property is within 300 feet of the discussed property, and our property lines butt up against each other.
Good evening. My name's Lachelle Wilfong. That's Lachelle. Wilfong is Wilfong. My daughter and I are here tonight because we live at 66 Flintlock Lane, which is at the very heart of the cul-de-sac that would be disrupted. We also got the letter stating it'd be within 300 feet of the project. Thank you.
Hello, Amanda Gensimer. I'm at 72 Flintlock Lane, and I also got a letter that I'm within 300 feet of the property. Oh, sure, sorry. Gensemer.
Hi, I'm Frank Donatelli, Donatelli, 1495 Valley Forge Road, and I share the driveway with the conference center. So I guess I'm within 300 feet.
Stephanie Quigley, it's Quigley. I'm at 39 Flintlock Lane. My property butts up against the property line.
Hello. Rahima Mablo, 10 McKinney Lane. It's 300 feet from subject development, and I received the letter as well. So could first name R-A-H-I-M-A, last name M-A, V as in Victor, L-O. Thank you. May I?
Michael Repasky, R-E-P-A-S-K-Y. I reside at 5 Flintlock Lane with my wife and 4 kids, and we received a letter that the development will be within 300 feet of our property. I'll fill this out and get this to you, sir.
Thank you.
Good evening. My name is Fred Conner, C-O-N-N-E-R. I'm the Director of Operations for Founding Forward at 1601 Valley Forge Road. We are an adjoining property.
I am Barry Molzett. I live at 62 Flintlock Lane, and I also received a letter. I'm within 300 feet of the property. It's M-U-L-Z-E-T.
My spouse to be a party as well. Could I give Mark?
So Mark, if you've indicated that yourself on the list, you can also indicate your spouse.
I
So
did.
you did, then
Could I have her to record?
that'll be noted. What I'm going to do is I'm going to mark as Exhibit B7 the collection of party status request forms. And we're missing just the one. Okay, last call for party status. Okay, before I turn it over to the applicant, just a quick summary of the application tonight. Maybe more importantly, what tonight is not. So this is an application to demolish certain historic resources on the property, the 1485 property. It is not the approval of the development writ large. That goes through an entirely separate process before our Township Planning Commission. It's called subdivision land development. That goes through engineering reviews. It looks at a lot bigger picture of the things. Thank you, Michael. A lot bigger picture of the things that we are looking at tonight. Tonight we're really focused on, it's section 370-55, which spells out when someone can demolish a historic resource and the factors that play into that. Okay. With that, we'll turn it over to counsel for the applicant to begin her case in chief.
Good evening, everyone. Allison Zaro, writer Record Home in Colorado. I'm here this evening on behalf of Scotia Property Investment LP, which is an entity of Bentley Homes. Bentley's entity is the actual owner of the property. Oh, yeah, I was wondering about that. Okay. Do you want me to start over or, okay. Should I start over? Okay, yes, okay. Good evening, everyone. Allison Zaro on behalf of the applicant, Scotia Investment Properties LP, which is the equitable owner of 1485 Valley Forge Road. As Mr. Crotty indicated, we're here tonight for a conditional use hearing specifically pertaining to 2 Class 2 Township historic resources, and we had originally filed a request to demolish them. There is a dwelling that you'll hear about, which was considered to be a tenant house, and there is a barn on the property, which are the 2 Class 2 historic resources that the application will be addressing this evening. We did appear before the Historical Commission on 2 occasions, and representatives of the Historical Commission also walked the site. They ultimately recommended, as you'll hear tonight, that the dwelling on the property be demolished. However, they recommended that the barn not be demolished. And you'll hear tonight that my client is willing to retain the barn on the property. There are some modern additions to that barn that we would still like to demolish. As you'll see when we go through the pictures, they're incongruent with the actual bank barn itself. So although we are modifying our request this evening, we would still want to demolish those modern additions, but we would save and stabilize the barn on the site. Mr. Crotty had also mentioned, again, that we're here tonight about that, and I did want to note that my client is proposing to develop the property with single-family residential dwellings.
However, that is something that is permitted in your zoning ordinance in the R1 district by right. So we are not here tonight specifically regarding the overall development application. And I note that we did file a concept plan with the application, which is marked as an exhibit that I'll hand up to the board. However, we do also acknowledge that we would need to make adjustments to that plan in order to save the barn in its current location on the site. So I just wanted to put that out there before we got started, because I know it is a little bit different than what we had originally filed. I do have a pre-marked packet of exhibits to hand up to the board, and I have two witnesses that I would call this evening. Jesse Carpino, who is a representative of the applicant, and Samuel Pickard, who is our historic resource consultant, who did a lengthy historic resource impact study that was submitted with the application and discussed with the Planning Commission. Does someone want to be, do you want to be a hander-upper, or do you want to? In order to keep things moving, I will use one of my assistants over here to hand up the pre-marked packet of exhibits. So we have marked as Exhibit A1 the application that we filed, submitted under a cover letter of myself, dated December 3rd, 2025. Exhibit A2 is the Township zoning ordinance incorporated by reference. That is not in your packets. And the first exhibit that we'll start with my first witness is Exhibit A3, which is a redacted agreement of sale dated July 17th, 2025, between HIS Property Holdings LLC as seller and Escotia Investment Properties LP as purchaser. And with that, if I could have Jesse Carpino be sworn.
Jesse Carpino, C-A-R-P-I-N-O.
Thank you. I guess we're sharing a mic. I was just thinking about this. Okay, just so I know what we're doing. Jesse, if you could just state, you have already stated your name, but if you could state your title and position for the record.
Sure. I am the Chief Operating Officer for Bentley Homes. Our office is located at 1595 Paoli Pike in Westchester, PA.
And Jesse, what is the relationship between the applicant? Oh, thank you. What is the relationship between the applicant and Bentley Homes?
We're an affiliated special purpose entity.
And are you authorized to appear and make representations on behalf of the applicant and Bentley this evening?
Yes.
I had referenced earlier, we have marked as Exhibit A3 a redacted agreement of sale. Is based on that redacted agreement of sale, is the applicant the equitable owner of the property?
Yes.
Our next exhibit is Exhibit A4, which is a property aerial. And I'd like you to identify the location of the property and describe where it is for the record. I don't know if that's something that might be the first exhibit we try to pull up on the screen.
Okay. So 1485 Valley Forge Road. The property is further identified as UPI number 27-6-118. It has boundaries by the red line on the picture. To the east is the Schuylkill River, and to the west of the property is Valley Forge Road. And it's about 46.7 acres.
And are there other residential properties that abut the property as well?
Yes, there are. To the north, Flintlock Lane are some residential properties. To the west and south, there's a handful of properties.
And is the property occupied today?
No.
What was it most recently used for?
The property was previously the conference center at Valley Forge.
There are 2 larger mission buildings located on the property, and there are also 2 Class 2 historic properties, one being a dwelling that has been renovated and expanded upon, over several of years. And most recently, it has been utilized as a multifamily dwelling. The other structure is the barn structure. That also has newer additions to it, and appears to have been used more recently as a storage area.
And with respect to, you mentioned the 2 mission buildings on the property, those are non-historic, or those later 20th century buildings?
Correct. They are non-historic.
And so, although you would propose to demolish them, they're not part of this application this evening, is that correct?
Correct.
In terms of a couple of other features identified on the property, there is a spring house. Would you be proposing to retain the spring house?
Yes.
And a cemetery, which is what I will call a later year cemetery. It's not also historic, is that correct?
Correct.
Are you also proposing to retain that on the property?
Yes, we are.
Okay. Did you appear before the Historical Commission on December 15th, 2025 and January 20th, 2026? And did the Historical Commission issue a written recommendation dated January 26th, 2026?
Yes, I did.
And we have that marked as Exhibit A5. If you could summarize your discussion with the board and what they ultimately recommended and what you have now proposed to do in response to their recommendation.
Sure. Our application was approved in part. The Historical Commission recommended that the approval to demolish the dwelling but preserve the barn structure on the property. Since that meeting, we have since gone through and obliged to keep the barn structure and its core and preserve that on the property.
And
recording in progress.
And we have marked as, and we'll get into the details with our our historic preservation consultant later. But in terms of the application, did you engage AECom to prepare a historic resource impact study, which we have marked as Exhibit 8-6, which was updated January 16th, 2026 in response to the Historical Commission discussion?
Yes, we did.
And on page 8 of that report is another area of the property, which we have marked as Exhibit A7. And if you could, once that's pulled up on the screen, if you could walk through in greater detail the specific area where these historic resources are located.
Sure. So on that image we're looking at, the historic structures are located to on the northern end of the property toward the middle. And so there's the dwelling, the barn structure, the stone house or stone spring house is located kind of where the cluster of yellow arrows are pointing. The cemetery is located further south of that. Both of those will be in non-disturbed areas. So the historic structures are outside of the yellow that you're looking at.
And in connection with the initial conditional use application, did you also have your structural engineer, SE2 Engineering LLC, prepare a report about the structural integrity of the Class 2 structures, which we have marked as Exhibit A8?
We did.
And was that also included in the historic resource impact study?
Yes.
How is the farmhouse dwelling described in that report?
The engineer identified areas of the existing farmhouse dwelling that do not conform to building code and require removal and or replacement. The existing flooring inside the dwelling is not level, which would require removal to properly level the existing joists. There's a series of penetrations through the existing stone structure, the historic resource that is identified on here. The roof is in beyond repair and will need to be replaced. And one portion of the dwelling has ceiling heights of about 7 feet, which does not meet modern living standards.
And also, did the report address the barn structure?
Yes, it did.
And I know there are several items related to the barn structure. You have indicated you're willing to stabilize the general location of that, so I will not run you through all of those, but that is listed in the report. Is that correct?
Correct.
Did you also retain Piombino Associates to prepare an appraisal of the real property that evaluated the current condition and the overall value of the historic structures, which we have marked as Exhibit A9?
We did.
And how is the condition of the farmhouse and how is the condition of the barn described in that report?
So the appraiser was able to visually inspect most of the areas. There were a few areas within the structure that were inaccessible or deemed potentially unsafe at the time of inspection.
Excuse me, I'm going to object here. The appraisal report is a document which speaks for itself. The witness can't really interpret the appraisal, especially the structural integrity.
You need the microphone.
Oh, I'm sorry.
I can read it verbatim.
Thanks. I'm Michael Gill. I'm special counsel for the Historical Commission for this matter. I think this works. Oh, thanks. All right, thanks. I'm Michael Gill. I'm special counsel for the Historical Commission. I understand that the appraisal report was submitted as part of the application. That's fine as far as it goes. We don't have any objection to the report itself, but the interpretation of the report by the witness is objectionable.
So is the applicant?
That's fine.
That's
As long
fine,
if he
okay.
doesn't object to the report on the record, I can move on.
I do not.
That's fine.
Yeah. You had mentioned that despite the fact that you had the structural engineer look at this, you have now committed to preserving the core of the barn. And if you could just clarify a little bit about what you would want to do with
Sure.
that.
So we would remove the modern additions to the barn. We can get to the core of the actual barn, historic barn structure. We would. We're still asking for approval to demolish, like I said, the additions, the later additions, and certain features on the landscape surrounding the barn. But the core of the barn would be stabilized and retained.
And although not part of this conditional use application, was a concept plan, which we have marked as Exhibit A10, submitted with the application showing the development of 49 single-family detached residential dwellings on the property in accordance with the R1 district requirements.
Yes.
And would that be, if the board were to approve the application as presented tonight, knowing that you would then intend to keep the core of the barn, would that further be updated prior to any formal filing of a subdivision and land development application?
Yes, it would.
With respect to the barn itself, and assuming it's being retained, would the future owners of the residential development then be responsible for ensuring the long-term maintenance of the barn structure?
Yes, they would.
And would they also be responsible for the long-term maintenance of the dwelling if the request to demolish was denied by this board?
Yes, they would.
And is the applicant concerned about the future ability of the homeowners association to perform long-term maintenance obligations for these structures?
Yes, we believe there will be significant costs to maintain the barn over the years. We think an HOA could reasonably budget for maintenance costs of either the barn or the house, but to have both together would be burdensome on the HOA.
And are you concerned about potential safety issues with preserving the residential dwelling on the property, knowing that it would not necessarily be utilized in the same way as the other dwellings in the development.
Again, I'll object to that question. The witness has been offered as a fact witness on behalf of the applicant, not as an expert who can offer opinions about the structural integrity of the structure.
Let me rephrase the question. Is the applicant concerned about safety issues related to preserving the dwelling on the property that are non-structural?
Yeah, I think we are concerned it could be an attractive nuisance for children in the neighborhood.
And in the applicant's experience as a developer, would it be feasible to sell the residential dwelling to a single homeowner in the community?
No, the dwelling has been renovated several times over the years and is now arranged as a multifamily structure. The apartments do not meet code with 7-foot ceilings in one unit. The dwelling has also been stripped of its true historic integrity over the course of multiple additions and renovations, so we don't believe it would be an attractive, to a buyer from that perspective.
And have you looked at other adaptive reuse opportunities afforded under the zoning ordinance for historic resources such as multifamily dwellings, offices, inns, restaurants, or daycare centers?
No, although it is arranged as a multifamily structure today, the units don't meet modern standards and could not be occupied without major renovations. The unit sizes and configurations would not be compatible with any permitted use of the remainder of the property. And as noted in the various reports that we've supplied, extensive mold remediation would be necessary to allow any use of the structures, and we suspect that the issues would dissuade operators of restaurants and daycares and things like that.
And have you considered the economic feasibility of adaptively reusing the structures? I mean, you've touched on this, but have you further taken a look at what would be involved to rehabilitate those structures?
Yes, the structural engineer's report details the extensive rehabilitation that would be required to allow any use of either structure. The cost of those renovations and the lack of feasible adaptive reuses for the structures weigh in favor of demolishing the structures, particularly the residential dwelling.
In your opinion, is it feasible to continue what was the prior use of the property, knowing that it's currently not in operation today, but we'll call it the current use?
If the witness is being asked his opinion as a layperson, that's one thing, but again, the witness has not been offered as an expert to offer an opinion in anything.
Okay, fair enough. We have marked as Exhibit A11 a street view of the property from Valley Forge Road. And looking at that exhibit, can these structures be seen from the public right-of-way today?
No, they cannot.
And we'll pull that up in a moment. And again, that was Exhibit A11, which is the street view of the property. Would the access to the development be restricted? Is it your assumption that if a development were approved on this property, that the access would be private as it is today?
Yes.
And so as a result, is it your position that the public view or value associated with retaining that dwelling would be minimal given the public's inability to see it from the public right away?
Yes, I would.
Okay. I have no further questions for Mr. Carpino.
Mr. Gill, do you have any questions?
I do. Thank you.
We're going to get through all the parties to ask questions of the witness, correct?
As I said, my name is Michael Gill. I'm special counsel for the Historical Commission of Schuylkill Township. Your entity, Escocia Investment Properties, has had the property under agreement since the summer of 2025. Is that correct?
That's correct.
Were the apartment units in the farmhouse structure occupied at the time that you put the property under agreement?
In the dwelling, or sorry, could you repeat?
Were the apartment units in the farmhouse dwelling occupied at the time that you put the property under agreement?
I believe they were.
And remind us again what you said about the use of the barn prior to your period of equitable ownership?
Looked to be used as storage.
Okay. Was there an apartment in the barn structure?
There is apartments in the barn structure, but the ceiling has since collapsed throughout the addition where the apartments were in the barn.
Okay. I'll come to that in a moment. But my question was the apartment in the barn structure occupied at or around the time that Escocia put the property under agreement?
I do believe they were, yes.
Okay. So the apartment units in the farmhouse and the apartment unit in the barn, it's your testimony, they were occupied as recently as summer of 2025. With regard to the structural engineer's report regarding the farmhouse, are any of the issues that the structural engineer identified structural failures?
I think it's hard for me to opine on that. Structural failures, well, I would believe that, with time, it hasn't been maintained, so things tend to fail.
All right. And likewise, with appropriate stabilization, the failure could be prevented, correct?
I would say not without significant resources added back.
Okay, we'll come to that in a moment. You testified about let's get into that. You testified about long-term maintenance costs that the HOA would bear. It'll be your business entity that will create the homeowners association, correct?
Correct.
And it'll be your entity that builds out the development that will be the basis for the homeowners association, correct?
Correct.
So it's your testimony that you would simply form the homeowners association and say, here are the resources, without seeding the homeowners association with a budget to be able to maintain the structures. Is that correct?
No.
So you would commit to seeding the homeowners association with maintenance funds, correct?
We would never hand off something that was going to be an immediate liability to our homeowners.
Okay.
But over time, just like everything in an HOA, you have to reserve for certain components. This would be a reserve that an HOA would set up.
And that would be something that the owners of the homes in the community would know about as they move to buy their homes, correct?
Correct.
You say that the farmhouse structure would not be attractive to buyers. Have you conducted any market analyses to determine what an appropriate use of the farmhouse structure might be?
Well, we've looked at it from, what our intended development is going to be. Having the permitted uses that are allowed by ordinance inside the community would not, in our opinion, would seem like a viable option. As we mentioned earlier, the daycare or an inn, I believe, is also permitted. We do not believe would be permitted uses inside a residential development.
Okay. My question was, have you conducted any analysis, any economic analyses of any of the potential uses beyond your conclusory statements?
No.
Would you turn your attention to the structural engineer's report, which is Exhibit A8? With regard to the farmhouse, let's start there. Bullet point number 2, or comment number 2, the existing roofing is beyond its lifetime and must be removed and replaced. The cedar shakes exhibit mold growth. Are there any other references to mold in the farmhouse in the structural engineer's report?
I don't believe there's any mention of mold in the farmhouse, no.
Okay, now you testified earlier that there was extensive mold. Were you referring to the barn then?
Into the barn, yes.
Okay, so there's not extensive mold in the farmhouse, is that correct?
No, I do not believe that to be the case.
And again, according to the structural engineer, the mold in the farmhouse is in the roofing, correct?
Correct, it would appear that way.
Just out of curiosity, when you put the property under agreement in July of 2025, has your entity taken any steps as the equitable owner to prevent further water infiltration into the farmhouse?
Utilities have been ceased to prevent any kind of future growth of mold, water.
I'm sorry, can you say that again? I didn't understand what you said.
Utilities have been stopped at the property to prevent, future water infiltration. But the roof does not appear to be leaking in the farmhouse.
Okay. The structural engineer commented about mold growth in the roofing structure, in the shingles. Has your entity, as the equitable owner, taken any steps to secure the roof to prevent further mold growth?
On the roof, no.
Okay. On Thursday of last week, I visited the property with representatives of AECOM, representative of Scotia, and your council, and with the Township Historic Preservation Consultant. At that time, are you aware that there was a water leak in the barn structure? An active water leak?
I was not made aware of that until the day of.
Okay. You just testified a moment ago that all water service at the property has been ceased. Can you tell us what the source of the water leak that we observed on Thursday was?
Well, the property manager has alluded that they're still the property manager. Our seller has told us that the utilities have been discontinued. The leak that I come to understand happened last week in the barn. I'm not aware of where that came from, whether it was an active water line or not.
Okay. All right, that's fine. And I'm sorry, I didn't mean to try to trip you up, but you testified about the utilities being turned off, so I just wanted to make sure we were clear on that. With regard to the barn structure, where in the structural engineer's report do we find reference to the extensive mold that you testified about a moment ago?
Sorry. On that page. Number 12, under the barn. Due to the large quantity of water infiltration into the barn area and lack of mechanical systems to control the moisture, mold is present within the structure.
Okay. That's not a reference to extensive mold, is it just mold?
Well, it also references where is it? Trying to see where he's got that deterioration. They mention in one, the roofing is currently leaking in several locations as evidenced by darkened wood and mold on the underside of the shingles. Missing decking observed in one location. New roofing is required for the structure.
Okay. So there's mold on the roof of the barn. There's mold because of water infiltration. Do you know how old the roof on the barn is?
I'm going to object to that. We do have a historic consultant that will walk us through more about the structure.
Fair enough.
Is that really an objection, or is that more?
It's more, I guess, more of a.
I'll withdraw.
I mean, it's
Okay.
more of a. I have somebody else that'll testify
I got
to
you.
it.
Yep,
Yeah.
thank you.
Has your entity taken any steps to stabilize the barn or to prevent further water infiltration into the barn structure?
We have not made any improvements to the barn structure, no.
Okay. So no steps have been taken to prevent further deterioration of the structures in the 8 or so months since you've been the equitable owner. Is that correct?
Correct. There is a property manager for the property that maintains the property.
Okay. Now, again, to state the obvious, your entity doesn't own the property, correct?
Correct.
All right, so you have not made any capital investments in the property yet, correct?
Correct.
When you took equitable ownership of the property, when you put the property under agreement, was it was it your entity, your business entity, who directed the owner of the property to terminate the tenant's leases?
No.
The seller decided to do that on their own?
Correct.
Okay. When you put the property under equitable ownership, under agreement, did you do so with the expectation that these structures would be removed?
Yes.
I think we've already covered this, but I just want to make sure. If you please, do you have the exhibit packet there?
Yes.
Would you please turn to page 26 of the AECOM report? I'm sorry, page 28, excuse me. Photograph 34. You see that there?
I do.
Has your entity taken any steps to remove the water damage or the flooded cellar in section D of the dwelling that's depicted in that photograph?
No.
Okay.
As I mentioned, there's a property manager.
Has your business entity performed any cost analyses of the cost to remediate the mold that is referenced in the structural engineer's report?
Cost for mold remediation? No.
Correct. And again, your entity hasn't taken any steps to conduct any cost analyses to complete the remainder of the improvements that the structural engineer recommends, correct?
Correct.
Yet your position before the board is that the costs to remediate would exceed the value of the resources, correct?
Well, given that our own structural engineering report identifies significant structural reinforcement and updates and replacing roof, I mean, we are in the construction business. Without an itemized report of what it would cost, we have generalities of, this being a significant amount of money to restore.
Have you put a number to that other than the general qualifier of significant?
Again, depending on what it was actually, what adaptive reuse was going to be selected, or restoration, it's pretty difficult to ascertain that nominal value or that numerical value.
Okay, I'll take that as a no. Would you please grab that HRIS again, and this time turn your attention to page 37 and 38. Excuse me, I'm sorry. Allison, have these page numbers changed? Or is this
Slightly.
Okay, all right, so I'm not crazy.
Yes, there are a couple of paragraphs, as I mentioned at the beginning, there were a couple of paragraphs that were added per questions from the Historical Commission, so as a result, I think it shifted a couple of things as you go through the report.
All right, thanks. All right, would you please turn your attention to pages 39 and 40?
Okay.
And so now we're in the forebay of the barn, correct? With these photographs, photograph 53 and 54?
Yeah, you are in the forebay, correct.
All right. The structural report, or the HRIS, excuse me, the HRIS makes reference to a fallen ceiling. To your knowledge, is this the fallen ceiling to which the HRIS makes reference?
Yes, I believe that to be the case.
So that's just a modern drop ceiling, correct?
Correct.
All right. So the interior of the roof of the, or the underside of the roof of the barn is not itself collapsing, correct?
No, I believe the structural engineer mentions in his report that the rear barn roof needs to be replaced.
Okay. It needs to be replaced, but when your consultant talks about a collapsing ceiling, he's talking about the modern drop ceiling, correct?
Correct.
Now, the Historic Preservation Ordinance, Chapter 370, I'm sorry, Article 9 of Chapter 370, requires certain information to be presented with an application with the conditional use application for demolition of structures. Are you familiar with that ordinance?
Yes.
All right. Part of the information that's required to be presented is the purchase price of the property. Do you understand that?
Yes.
Have you presented to the township the amount for which your business entity, Escocia, has the property under agreement?
We have not purchased the property.
That wasn't my question. My question was, have you presented to the township the purchase price that is recited in your agreement of sale?
No.
Okay. When you say that the costs to remediate will outweigh any economic return or the feasibility of any economic investment, are you including in that analysis the price that you're paying for the property?
No, I don't believe I am, no.
Okay. I'm going to show you what's been marked, what I've pre-marked as Exhibit HC4.
Yeah, okay.
Have you seen that document before?
Don't believe I have. If I have, it was probably a while ago.
All right. Going back to Exhibit A3, the agreement of sale, it identifies the seller as HIS Property Holdings, LLC, and HC4 identifies the grantee in a deed from July 16th, 2025, as HIS Property Holdings, LLC, and your agreement of sale is dated July 17th, the next day. Is it your understanding that the grantee identified in this deed is your seller?
Yes.
All right. Now, would you turn your attention to the last page of this exhibit? About midway through the page, does the document recite a county assessed value of the property?
It does.
And does it then have a computed value of the property?
It does.
All right. Are you aware of any efforts to change the assessed value of the property for real estate tax purposes?
I would object to that. To me, that's not relevant to the purpose of why we're here, the tax assessment.
The ordinance requires that the applicant submit information regarding the purchase price of the property or the value of the property. If the applicant isn't going to present that evidence to the board, we're trying to establish a value of the property otherwise.
So are you, underlying that, are you asking him whether the assessed value of the property is what he's considering is the true value of the property?
The document speaks for itself. It's a recorded document. What I'm asking him is he aware of any efforts to change that assessed value?
So I think you can answer, are you aware of any efforts to change the assessed value?
No, I'm not aware.
All right. Now, recognizing that we are not here to talk about the future development of the property, you've testified that your entity is willing to preserve the barn. Can we take a look then at Exhibit A10? Now, on Exhibit A10, the area in the center of the page that says Central Green, and then there's a drive aisle just to the east of that. That drive aisle, that Central Green, and then lots 28 and 29, that's generally where the farmhouse and the barn sit today, correct?
That's correct.
So by preserving the barn, that's going to require a redesign of this concept plan, correct?
Correct.
Have you conducted any analyses to determine whether the site plan could be further redesigned to preserve the farmhouse as well?
No.
The historic preservation ordinance requires that the applicant present a timeline for demolition. Have you presented a timeline for demolition?
If you're asking about something that's in the report, I could have my historic consultant answer that question when we get
I
to
was
him.
leading up to a question, and that is, if the Board of Supervisors approves demolition of these structures, when would your business entity move to complete that demolition?
Probably more than likely after land development approval.
Okay, and would you be willing to accept a condition that if the residential development is not constructed, that the historic structures should not be removed?
I think that's more of a legal question probably in some sense, but my question for you is in terms of this application, obviously, if for whatever reason my client were no longer involved, I don't know what the position of the seller would be, but.
Okay, so.
Do you understand what I'm getting at?
I do.
Yeah.
I do. So I guess my question then is, sir, it's possible that you could demolish that you could obtain approval to demolish the resources, but then not proceed with the residential development. Does that exist as a possibility?
I guess it's a possibility, but I would say that the likelihood of that is very low. We would need to have some security before we go and demolish any resources.
All right, as we wrap up, I just want to turn our attention back to that appraisal report. If I could, I'm sorry to go out of order here. The appraisal report on page on page 3 of the document refers to the property as 1 unit, 2.5 stories, an existing colonial structure, 191 years old. Is the value that the appraiser concluded in the appraisal report just for the farmhouse, to your understanding?
I mean, if you objected earlier to my witness testifying to this report, if it speaks for itself, it speaks for itself then.
Well, I objected to his characterization of the structural integrity of the building. I'm asking him what the report, whether as the party for which the report was prepared, if it's his understanding that the report only speaks to the residential, to the farmhouse. That doesn't require any interpretation or expert knowledge.
It would appear that the single-family detached dwelling on the appraisal report is what was contemplated.
Okay, so the single-family dwelling has a value, according to the appraiser, of $415,000 as of November 18th, 2025.
Correct.
And that, again, is in the condition as recited in the report, correct?
Correct.
May I have a moment? I have no further questions at this point.
Okay, now we're going to jump into the parties before the board or myself ask any questions. Mr. Barry Molzett, do you have any questions of this witness?
No.
Michael Rapaski?
No, sir.
Fred Connor for Founding Forward?
No question.
Rahima Mevlo?
I have several questions.
Well, please come up to the microphone, and if you have any questions, of this witness about his testimony. Okay, Allison, did you borrow the?
Yep. Hello. Just please bear in mind, English my second language, so I might need some time to verbalize. The tax situations, is this appropriate time and place to ask about tax implication of this project?
You can ask the tax implications of the project. You can ask the applicant if he had, what are you asking him about the tax implications?
Well, I believe this question is for Township, how this development will affect the existing real estate taxes for example, for residents that are within close proximity to the project, whether or not the taxes will increase from a township point of view, and whether or not developer is going to has an intent to apply for it's called tax abatement, because it's a large residential development, how that development would affect our taxes for residents that are in a close proximity to this development, and whether or not applicant developer is intent to file or intent to apply with the township for tax abatement, which is typically 5 to 10 years. Tax abatement are typically granted for new developments, and how is it going to affect everyone who is in the immediate proximity to development. So this is, as an homeowner, I would like to know what's going to happen to how that project is going to affect my real estate taxes. I think
Okay. So your question was, how will the property of the project affect real estate taxes of neighboring parcels, and whether they are intending on applying for any sort of a tax abatement program?
Correct.
Does the witness have any position on that? This is not a period for questions of the board. The board is the judge. The question itself is probably beyond the scope of what we're here for tonight. But if you have any answers to those that we can satisfy,
Sure.
that'd be great.
We do not intend on pursuing any kind of tax abatement. I don't believe I'm qualified to say how it would impact property taxes for neighboring parcels, but I would say we are not pursuing any abatements.
And it's going to stay on the record, right? That statement is going to stay on the record of the township.
It is, yes. Sure.
Okay, okay. And the second question, I'm not sure how to, maybe you can help me to phrase it eloquently. In my personal opinion, it's rather large development. For, how many acres? Would you refresh my memory, please?
46.7.
Okay, 46 acres, and how many townhouses planned to be?
There's single-family detached, and there are 49.
49. So 49 townhouses, less than an acre each townhouse, right? And approximately 49 townhouses, an average household occupant would be 1 to 2 people. So if you take 2 people, multiply them 49, you have 100 people approximately.
I'm going to ask if there's a question here.
I haven't finished my...
Questions of this witness. Do you have any questions?
I do. I haven't finished my question, if I may. I will get to it. I'm trying to structure my question. So the population will increase. Population, cars, noise, pollution, traffic, possible increase in real estate taxes. So how is this developer willing to mitigate? You know, also wildlife will disappear, you know, wildlife. Greenery on a property, greenery, vegetation will be cut down. Wildlife will disappear. So as a developer, do you have any proposed kind of a neighboring property improvement as far as, you know, for example, McKinney Lane is a private road, If I could interject.
Could I please finish my question?
But if I could say that it's outside of the scope.
Well, I haven't, ma'am, with all due respect, I can't fight, because I can only take one person. Yeah, I haven't finished my question.
So I think your question relates to the.
Public resource.
Hold on one sec. I think your question relates to the potential larger impacts of the development that they're proposing, is that correct?
Also, access to, like, for example, water, public sewer, and gas, because on McKinney Lane, everything's private, we don't have anything. Whether or not this developer is willing to work with neighbors that will be directly impacted by this such large, rather scale development. And if we, one way or another, I'm sorry to say, if we will benefit or we're going to suffer of 2 years of development, and is there anything this developer willing to provide for residents who is going to be directly affected? Property value, real estate taxes, wildlife, you know, the charm of living in Valley Forge, and that everything is going to disappear. Is developer going to help us to improve our life in the form of public sewer, public water access, sewer, and gas? It's basics.
So just a reminder, so that the purpose of tonight is just
Demolition
for
of
the,
historic
hold on, the
property.
demolition of the historic resources.
Sure.
There's an entirely separate process that the developer, applicant, anyone has to go through when they're subdividing or developing the property. And that goes through usually several rounds before the Township Planning Commission, several reviews by the township engineer, and several different iterations of plans. At each of those stages, anyone can talk to the applicant as to whether they want something buffering or something else out of the development. But what we really need you to do is limit your question to what's just before us tonight, which is the demolition of the historic resources, not the construction of any homes.
Yeah, but in a sense, it's kind of related, because once they demolish the building and they have a green light to do whatever they like to do, it's, you know, our chances will decrease with time.
So to be clear, so if this board were to approve or deny the demolition of the historic resources, that doesn't impact whether they have X number of homes on the property. That is an entirely separate process. So I will ask you, limit your questions to what the witnesses testified as to the ownership of the property, the maintenance of the historic resources, and their proposed demolition.
Okay, what is is it possible to object to demolition of that historic property, and how do you go about it?
So you can certainly object to it. You need to look at the zoning ordinance in terms of what the criteria are for it, and articulate whether you believe they've met those standards or have not met those standards.
Okay, so I guess we need legal representation, right?
That's up to you. You're certainly entitled to legal representation if you want it.
Okay, thank you.
Thank you. Stephanie and Sean Quigley.
No questions.
Frank and Diana Donatelli.
No questions.
Amanda, oh geez, I'm going to butcher your last name. Gensimer?
That's me. Can my husband answer
Amanda.
the question?
Yes.
Is that allowed? Amanda. I'll take
I feel like that's skit. I'm sorry. Yep.
Good evening. Bradley Gensemer. Gensemer. I just had a question about subsection 370-56, demolition by neglect. As a person who has legal custody or control of the buildings with your agreement, I suppose, and now that we know that there was water structural damage, something happening there, what are you going to do to fix or ensure that there's not more damage to those buildings until all of these things are done? Section 1, foundation integrity, structural members of the ceiling and roof, lack of weather protection, and deterioration of any of the features. All of those things are listed as having to be
Done.
done?
So I guess in two parts to that. So the long-term damage that, I believe ACOM and my structural engineer have identified are not recent, it's over prolonged amount of time. Second part of that is, with the preservation of the core structure of the barn, we would move to have it, further neglect to the structure. So whether we have to replace the roof, whether we have to, brace the walls, install members for the structure, that's the things we would have to do.
Great, thank you. Lachelle and Kevin Wilfong.
Hello, Lachelle Wilfong, Wilfong. A couple clarifying questions. It was spoken to earlier that the cost of repairing the damage, extensive mold that may or may not have been extensive, it would be passed along to the future homeowners association, and while it was likely that the cost eventually could be covered for one of the properties but not both, I'd like to better understand, there was no estimate that was given, so it talks broadly about estimate of repair, but there's no specifics. How do we know that that's true, that it is sustainable to fix one, not both, not neither? It seems nebulous. That's my first question.
I would say that, because we've hired our historical consultants who've had to address a bunch of things throughout this, not just the rehabilitation costs, and our structural engineer who did the same, in speaking with our consultants and our experts, the amount of, and it's not just mold, it's, structural members, in the barn that need to be replaced. The, stone has to be repointed, and, there's certain people that do that, there's certain people that don't, and, usually they come with a premium. Going back to the house, because you don't have a copy of the report, but the house was kind of divided up into 4 different sections. There are, and that over a number of years. So while the core that we speak of, it's almost very difficult to see what the core of that structure is. And it's been penetrated through additions over the years, so it's restoring that back into a functional use that we can actually use is very difficult.
Another follow-up question, thinking about the lack of oversight for the water damage that's occurred, that you may or may not have been notified by the property manager. How do we know that this is in good faith, that you're going to continue to take care of the property when you may not have to date, and it's just going to worsen the state and the condition of the property by the time it goes to subsequent steps in this process?
So with the, our recommendation, or the historical commission's recommendation to preserve the barn core, it would be in our best interest to not let it further neglect, and it's even part of the ordinance, demolition by neglect.
Right.
So what we have to do in order to restore it, or not restore it, but get it back to a safe structure is what we would have to do, and I don't see why we would want to let it prolong further if we knew that, more damage equals, eventually more money as well.
And then my last question, from what I understand, typically you seek approval to do it as you wish to a property and then go after the approval for historical commission. Why was the process changed this time to go for the historical approval first? What's the strategy behind that?
It is a condition before the Board of Supervisors can opine on any plan. if there's the demolition of historic resource, whether it's class 1 or class 2, that has to be first reviewed before any land development could be reviewed.
Thank you. Thank you.
Thanks, Lachelle. Abigail Freed.
Hi, Abigail Freed. So you just said that in order to get the property or those structures back up to a safe environment, there's extensive work. So in your opinion, these structures are no longer safe. Well, the structures, were the structures inhabited, or we heard that the structures were inhabited as housing up until last year. So was it so up until that point, unless in your opinion, or I guess here's my question, in your opinion, was the previous landlord creating an unsafe environment for their tenants
Well,
when you took over the property?
so I can't speak to that, but the from our structural engineering reports, a lot of the conditions in the existing dwelling and barn house were not up to IBC codes, international business construction codes.
Well, so I would like a distinction between what is considered safe per code and what is considered safe for a structure. An unsafe structure is very different than a building code, which we know has many exceptions for existing construction. So that's it.
Okay.
Do you have any response to that?
I guess my response to that is well, I'll go back to her original question of, was the previous tenant or the previous landlord allowing their tenants to live in non-safe structures? For our purposes of, why we're here tonight, a safe structure, obviously we want to leave our HOA with a structure that's not, that is structurally sound. We mentioned previously in our report that, these could invite, attractive nuisances. We would want to make sure that, God forbid anything, we want to make sure that these buildings, are sound for our tenants.
So am I allowed to say something?
Sure.
Is it a question?
No.
Okay, so I'm not shutting it down. It's just that there will come a point in time when you can make comment toward the end of the hearing.
Okay, thank you.
Thank you. Mary Donovan?
Is it too late to add my husband, Mark, to the list? M-A-R-K?
I'll write him in.
Thank you very much. So my question builds on some of the other questions, and I need a little bit of clarification here. We've talked at length about the estimated cost to repair and to make these structures safe and sound for the community that will come into this space. My understanding is that it is the property owner's obligation and responsibility to maintain historic structures. And as the applicable owner, that responsibility is also handed down to you with the inheritance of these historic structures on these property. As the applicable owner, it is now also your responsibility to maintain the historic structures. How does this impact the previous statement that the cost would be handed down to the HOA? If you want to opine on that.
Sure. While we would, in some point, be the owner of the property, as this transitions to an HOA, we will no longer be the owner of that property.
And what does that mean for the development phase and for the ongoing plans for development? Because I understand what you say is a future state, and HOA would be the development owner and they would have the responsibility. But what does that mean for today and for the 5 years it would take for this development to come into place?
Correct. So we would be incurring those costs as the developer to provide it so it's not a burden day one for our HOA.
Got it. So that cost, just to be clear, that cost to restore the barn or the historic structures, let's say, would be incurred by Scotia or Bentley. It would not be a cost that we pass down to the township in any way.
Correct.
And I understand, last question, I understand that this is a hearing about the conditional demolition of 2 historic properties. And I will question, it's hard to say yes or no in either direction without understanding what is going to replace those structures, and that the sketch plans that have been submitted so far will need to be adjusted. Is there an estimated timeline on when those new sketch plans would be available for public viewing?
As soon as we submit it to the township, they will become public record.
And your timeline for that?
Depends on how everything goes.
Ooh, okay, thank you. No more questions.
Jameson Glennon. Ellen Berry.
No comment, but I do need to add my husband, possible.
Sure, what's his name, Ellen?
Stanley Barry.
I can't read this one. Mirka?
No comment.
Thank you. Dana Jacob?
Could you please add my husband Andrew? Thank you. I'm wondering who the property owner, who the property manager's employer is.
The seller is the property manager.
Okay. And then you said before you didn't know what the cause of the water main break was. When will you have that report and who will produce it?
I will get with the property manager and find out.
Okay, thank you.
Rich and Julie Pace?
No comment.
Megan Turbino?
May I add my husband, Anthony?
Anthony, yep.
Sorry, I thought just household address covered the party. I would like to, you put up an image earlier depicting the proposed plans for the property, and they are viewable to the public right now as well. According to those plans, the entry for the development is going to become a very large boulevard and moved closer to Flintlock. Would not then the barn and the dwelling now be viewable to the public from that street entrance, considering the length of the boulevard and the distance that it goes back?
It would depend on what kind of shrub, trees, all of that would be in the line of sight. Currently,
Go ahead.
where the proposed entrance is right now, if you go there, you would not be able to see it. It's very difficult to even see it at all from the current entrance.
Is that not due to the overgrowth of the property?
I mean, in that section, there's not too much overgrowth. It's primarily trees.
But you are proposing to clear that land?
Currently, in that section, abutting Flintlock, there's some trees, but it's an open field right below that. And then it hits the main entrance, the current entrance.
If the structure were to remain, is there any plans to make it more accessible to the public? To be able to view it more clearly?
That would depend on how things are worked out through land development, because these are currently contemplated to be private streets. A public resource on private streets would not make much sense right now.
This is probably not a question for this meeting. Private streets as in gated, unable to be accessed from? Okay.
No.
All right, that was the last. I know that's for a different meeting. All right, thank you.
Thank you. Keith and Tammy Wickstrom?
I just want to make a clarification. Scotia took over the property on July 17th, 2025, and Friday, February 6th, Aqua PA shut off the water to the barn. Just to clarify that.
Are you asking him to confirm that?
Yeah, would you confirm that? Because I think you kind of led us to believe that when you obtained the property, you jumped right on taking care of the utilities.
So our property manager, we do not control we have an equitable interest in the property.
Right.
the ongoing maintenance of the property, mowing, et cetera, is not conducted by by us.
So you take no responsibility up to this point in time, but you're going to be taking responsibility from this point in time moving forward, is what you're saying?
Well, we are working with our property manager to ensure that everything is shut off.
From this point forward?
Yes.
Okay, just wanted to clarify that. I looked at the development plan, and this really, the conditional use application is part and parcel to the overall development of the property. And in looking at the plan here the other day, I noticed that you had 35.21 acres of net developable acreage.
Sounds right.
Sounds right. The previous developer had 31.22 net developable acres. My question to you is, how can they be so different? That's 4 acres. 4 acres is, that's all of the properties on Flintlock Lane.
But I think you can ask to, you can
On the
answer to
south
the
side
extent
of
you know.
Flintlock Lane.
I mean, the prior, I don't even know who the prior.
Well, can you walk us through your calculations? Sure, yeah, yep. Okay, I'm sorry.
The only thing I could say about that is that we hire professionals to determine this information for us. Whether somebody else got 31 or 33 or 29 and we got 35, it's really beyond my expertise.
And who
I'm not an
will
engineer.
make that determination then?
So
As to which
generally,
is correct?
the review of the land development plans, when they come in, it comes to the township engineer for him to do a review, and then also our planning commission.
Okay, all right. I would suggest then in your development plans to maybe go back and look at those numbers, just in case you are wrong, because then maybe the 49 homes isn't right. Maybe it's 25, who knows? So you may want to go back and check those numbers.
Okay.
Thank you. Mark Harville?
I get to say my line now, right? You all know where I'm going. I apologize. Mark Harville, Harvill. Hi, Jesse. Thanks for your time tonight.
Thank you.
Just a couple of questions. I looked at your plan, and it seems to me that it's currently designed for the barn to be removed, for both the house and the barn to be removed, because there's 2 of your units sitting on it. And you suggested earlier that you haven't come up with a contingency plan or a plan B for what to do if the barn doesn't go. Is that the case?
No, we've actually, since our historical commission meeting, we are keeping the barn.
Okay, so you've redesigned that drawing around the barn?
Yeah, we'll have a revised sketch.
Okay. Does it entail or constitute a reduction in number of units that are going in there?
It hasn't been completed yet. I can't
been
say
completed.
whether it has.
Off-the-wall question. Have you done had any consideration or cost analysis for moving the barn someplace onto the undevelopable land?
There was discussions about other mitigation efforts during our discussion with the historical commission. But you run a risk of relocating that barn and trying to recreate the exact structure that you had. Also, I mean, you know, the existing stone, you know, different applications of mortar. So it was discussed, but only briefly.
Okay.
I think keeping it intact in its place where it's been was more of importance than that.
All right, understood. Last question. Some of the pictures I saw of the interior of the barn and the house were pretty scary, given the structures that have, the supporting structures that have been removed from the barn underlayment, where some of the columns have been removed, and also the electrical systems looked like they were done by drunken monkeys. Is it your intention, if you retain the barn, to redo all the electrical and everything else as well, or?
We still have to come up with a game plan for it. Currently, it's contemplated for preservation, and we'll figure out what exactly that looks like inside the barn as well.
All right, great, thanks.
Thanks.
Okay, so that concludes the neighbor questions. Do any of the board members have any questions of the witness? I just had a few follow-ups. You were asked earlier if there were a condition that you'd need to demolish a building, you were approved to demolish it, you do it after the land development. if there was a condition that one of the buildings, like the barn, were to be preserved, when is that preservation going to take place?
Wouldn't that immediate? I don't know if I can answer that.
Are you going to wait till after land development to start the?
When you're talking about preservation, you mean the stabilization?
Correct.
Taking off, if we received
Oh.
approval, taking off additions, which our historical consultant will get into the details of what we're talking about.
Okay.
What's new, what's old on the barn, but you're saying that work, when would that be done? I think that's.
That would, yeah, that would be done during land development.
And then you mentioned before, I think you were asked before, what steps you've taken to stabilize the barn or take care of the flooding in the basement, and you noted you haven't taken anybody, but there's a property manager. Has the property manager taken any steps to either stabilize the barn or remove the flooding from the cellar in the barn?
I'm not quite sure if he has yet. Up till a few days ago, I thought and was assumed that all the utilities and everything were off. I think they are in part, but we will make sure that, moving forward, I think we've hit a pretty big cold spell these past couple weeks, so I think maybe that has something to do with it, but we'll be talking with him after this. Sorry, what was the second part of your question?
For the flooding in the cellar basement, has the property manager taken any steps to remediate that?
I don't know. I will find out.
And then for the multifamily use of is that of the dwelling?
Mm-hmm.
When did that start?
In the farmhouse, the multi-family building? I'm not sure when that was converted.
Do you know if the applicant or anyone else obtained any permits for the township to use that for multifamily dwelling purposes?
I do not.
That's all the questions I have. Any redirect from the applicant?
None at this time.
Okay. So we are past 8:30, we're at 8:39. Probably makes sense at this point because we do have a full agenda after this. To wrap it up for tonight, and then if the board's agreeable, we'd continue it to our March 9th meeting. Does that work for everybody? Still 7 p.m. It will not be re-advertised. This will be the only notice that it's continuing to that time period.
Ask you to go just for a moment.
Yep.
To make sure I'm available on March.
Yeah, so, yep. March 9th is the second Monday in March.
I am not.
Okay, why don't we go off the record then and look at calendars, if that's okay?
Yeah, and members of the planning commission, I'm sorry, commission will also not be available. If the applicant and the board are willing to schedule the continued hearing on another night, that would be very, very nice. I apologize, I'm out of town from,
So would you just mind using your mic?
yeah, I can't.
Yeah, we're off the record now, you don't need.
Don't know that I'll be back in town on the 9th.
When do you leave town?
The 5th.
Oh, okay. February 23rd? The 23rd.
Oh, 23rd.
Of February.
February, that's.
We have open space.
Wait, they can't do, oh, we have open space that night? Okay.
Not the, on the 23rd, we can't.
February 23rd.
We have a meeting, a different meeting that night, so we can't do February 23rd.
Bob, when do you leave the country? When do you leave?
Tomorrow morning. 3:60.
When do you return?
Returning the
March 5th? First Thursday?
I will not be on March 5th.
Oh, that's when you
yet.
leave.
With respect to the board, is there any way we could introduce a Teams, Zoom opportunity?
So generally, we do not do that for hearings because, it's for participants of hearings, because we need to manage the room. The court reporter needs to make sure to get everything of record that she needs to get of record.
I'm just thinking of the critical parties, if that would be an option for a limited digital age solution.
That's been tried before and failed many a time. We typically try to stay away from it, just because if someone has an exhibit, for example, that they're presenting in person for the first time, if they're the ones that are on the camera, they can't give it out to everybody. Or, it becomes a logistical, we've lived it through COVID, it becomes a logistical nightmare.
If I wrote my husband's name on the party paper, is that good enough, or do I have to say it on the record too?
Let me know in a minute, once we pick a
So-
date.
You said Kevin and Michelle.
Yeah, I think you already listed your husband's
It's
name
on
on
the
there.
paper, I don't know if I spelled his name, and so I want his opportunity to be here.
This is going to be embarrassing.
Okay.
I got my travel dates wrong. This is going to be very embarrassing. I'm now informed that actually we will be leaving on the 12th, not on the 5th. So March 9th is perfect.
Okay.
Sorry, everyone.
So everybody can do March 9th.
So March 9th. Okay. We can start it earlier.
Truthfully, the dates are already hard to book down. Are they? Okay, that's fine.
March 9th.
Regular business.
Okay, so we could do it 6 o'clock on the, we don't even need to advertise because we're continuing on the record here.
Are we doing 6 or 7?
6 p.m.
On
We're gonna-
March 9th. On March 9th. Okay.
Why not advertise?
Hold on a moment. Gail, you ready to go back on the record?
It will be published. It's just not going to be advertised from a procedural standpoint, but it will be published. It will be on the agenda that's posted, it just won't be on the newspaper.
Yeah, so we're back on the record now. The hearing tonight will be continued until March 9th at 6 p.m. Yeah, it will not be advertised in the newspaper. It will be on the township's website. It need not be advertised in the newspaper, so we will not incur the cost of doing so. Okay, and that'll conclude the conditional use hearing. Perhaps we take like a 5-minute break for everyone to gather themselves or take any kind of convenience breaks or whatever. Thanks.